I'm Jay Lazega. Welcome to this installment of L&J's Morning Break. We're happy you're here. Thank you all for all the texts and emails saying hi. We love hearing from you. Today, we are talking still about COVID. And today's session is titled, Are We Safe to Operate Yet? And probably most of you know the answer is going to be no, not really. But we're going to talk about that today. I am joined today by my good friend Jamie Lyons. Hi, Jamie.
Hello. Hi,
So,
everybody.
We hope you're enjoying these. We love hearing the great comments about it. We want to remind you guys that we've got earlier ones up on our website, ljlaw.com, under the resources section, earlier blogs, documents you could use, signage examples. We have a handout for you today. We've got earlier videos. We hope you share those with your board, with other managers. Feel free to use those. We are putting those up for you, and we hope they're helpful. We are going to continue to do these. We are focused mainly on the COVID issues, but we've talked about some others, including annual meetings, and we'll close with that a little bit later. But if we are going to continue using virtual video methods, platforms for meetings, which Jamie and I believe you absolutely should do, it's getting really close to time to start doing that. So we're going to do a class later in the month, I believe. Jamie, is that right?
July 21.
July 21 on virtual meetings. Come join us for that. But right now we're talking still about amenity openings and are we safe yet? And a lot has happened in just the last week, really 2 weeks. New legislature in their special session pushed out a couple of bills, passed bills that will directly affect community associations. And Governor Kemp has extended some orders, really not been as helpful as we wanted him to be. Neither is the legislation, frankly, but we're going to talk about those today and what they mean, and do they mean we're now safe? So we're going to start with Jamie. Jamie, go ahead, talking about executive orders and legislation.
So on June 29th, just a couple days ago, Governor Kemp signed another executive order, and really all it did was extend his previous executive orders, and really didn't change anything at all from the June 11th order. And essentially, Jay said we're still talking about COVID-19, and pretty much all of my information to you today is about still. We are still not legally obligated anymore to enforce social distancing under the governor's order. We are still no longer, it's still no longer illegal or a crime not to have a monitor at the pool. We are still required to prohibit gatherings of 50 or more during operational hours, which means we are probably still needing to have a monitor so that we can make sure we don't have gatherings during business hours. We still have to comply with CDC and DPH guidelines, which still say that we are strongly urged to enforce social distancing and to basically still have a monitor. And we are still obligated and have a duty to operate the pool in a reasonably safe manner. And we still don't know exactly what that means. And essentially what we think that means for the most part is that you've got to be complying with CDC and DPH guidelines with all of the different pieces to that, wiping surfaces and having a monitor and all the different pieces that we've talked about for weeks now. And probably still need a monitor to be able to make sure that we can argue if we need to argue. We've been doing this reasonably. We have created a reasonably safe environment. So again, as long as the governmental health and safety organizations are saying that we should enforce social distancing, we think that you still need to have a monitor to do that and to be able to operate the pool in a safe manner. So ultimately, the June 11th and now the June 29th orders really don't change much in how we think associations should operate your pool to minimize your risks and your liability. And if CDC and DPH end up changing their guidelines to alleviate some of these issues, which I don't think is going to happen anytime soon now that there's been spikes all over the country, then maybe we'll be able to change these protocols. but I don't think that's happening, in my opinion, anytime soon. And probably, in my opinion, not until we're done with our pools anyway. So I don't think it's going to be much different throughout the entire pool season, which then leads us to the discussion of, should you open your pool if you haven't opened your pool yet? And in my opinion, the answer is no. The risks haven't really changed. You know, when we start talking about liability issues, we may, if this law passes, which I'll get to in a second, we may have less potential for liability, which for me means less likelihood that we'll lose our lawsuit, a greater likelihood that we will win a lawsuit if we get sued. But we're still going to be in a lawsuit, and probably we're still not going to have insurance defending us. So probably we are still going to be on our own dime, paying for lawyers' fees, tens of thousands of dollars just to win the lawsuit. So we are still in the exact same spot as we were before, as far as I'm concerned, related to potential liability for financial implications related to the associations. So that was sort of the first thing that happened earlier this week, was the extension of the executive order. And the next really big deal that happened is that on June 26th, a couple days earlier, as Jay already said, the Georgia legislature passed the Georgia COVID-19 Pandemic Business Safety Act. Hasn't, you know, isn't law yet. Essentially, if it's not vetoed before August 7th, then it will become law. And it basically grants immunity from liability in two different ways. And only through claims that are brought or actions that would accrue until August 14th, 2021. So we've got about a year. Or sorry, July 14th. I didn't mean to say August. So there's essentially in this law two kind of layers of potential help for associations. The first is that the associations are not going to be considered liable for damages. So if someone sues us because they got COVID-19 or were exposed to COVID-19, or potentially a family member sues us for someone who died from COVID-19, we as a corporation will not be liable unless the party suing us proves that we were either grossly negligent, willfully and wantonly engaging in misconduct, we were recklessly inflicting harm, or we were intentionally inflicting harm. Those are these four levels of negligence and action that we would be taking that we can be responsible for. They're really, really high standards to prove. So it's going to be tough to be able to prove that. But I don't really know how to guide you on what these things mean, because I think gross negligence right now is really different than gross negligence would be a year ago. Is it grossly negligent to not have a monitor, to not, you know, wipe down surfaces, to not sanitize your bathrooms at all? And if DPH and CDC guidelines say that we should be doing that, couldn't it be considered grossly negligent if we're not? Which then comes back full circle to, we better have a monitor doing these things if we're going to open the pool. And if we're not willing to do that, frankly, I think we have generally the same liabilities we had before. The second way that this new law, if it comes into fruition, protects us is this. If we post this sign, the sign is in your handouts on the webinar. If we post a sign that's like a two-liner, it says, under Georgia law, there's no liability for injury or death. And essentially, if you show up on our premises, you are assuming the risk that you could be exposed to, or you could get COVID-19. If we have this special sign up, and the sign has to be at the entrance in each of the amenities, it has to be separate from other signs, it has to be in Arial font, at least 10 point, and it's got to say this one little sentence, two little sentences. If the sign is up there and we get sued by someone who came into our amenities and we had our sign up, our response to the judge is, listen, judge, these guys assumed the risk. They were told, if you come here, you might get COVID, and it's not our job to protect them now. It's their obligation not to get sick. They have assumed the risk, and they can't yell at us if they do. So if we have this fancy two-liner sign, then we are better off in the sense that we can argue that they've assumed the risk and we're not responsible for the damages that have incurred, unless, again, those same four things happen were grossly negligent, willful misconduct, reckless infliction of harm, or intentional infliction of harm. And again, couldn't tell you what those things mean. So it goes kind of far. It gives us an argument, but there are definitely still some risks. And again, full circle, still back to the situation where most carriers are not going to cover us if we end up getting sued. So we can make all our arguments and we can have less liability and we can feel like we're going to win, and we could win, and we're still paying attorney's fees out of our own pocket to get there. So you're still going to have to pay to defend yourself, probably. Whether you think that's a good reason to not open or whether you're willing to take the risk now, to me, it wouldn't be any different. No, whatever decision you made before, I would stick with that decision. But you might have some associations now who are more willing to take a risk, thinking that they're more protected.
Thank you, Jamie. I agree. The law, if it becomes law, will definitely help us, but it absolutely is not the total protection. They could have just drafted a law saying you will not be liable. The one that worries me in that list of workarounds is the reckless conduct.
Sure.
And people ask all the time, the Georgia Department of Public Health published guidelines. They're just guidelines. Who cares? If we don't follow them, who cares? It's just a guideline. But the answer is a plaintiff attorney is going to say, look, the standard for what is safe is not determined by you, Jay, the least smart person in the room. It's determined by the health professionals who are the smartest people in the room, and they say you should do these things. So if you don't do them, it constitutes reckless conduct. And we may try to defend that, but going back to what Jamie said, our great risk is defending that means lawsuit. 18 to 24 months and tens of thousands of dollars, which, if not paid by our insurance carrier, is problematic. Interestingly, we've talked about this before. On the other side, the decision to not open. We've actually had our first lawsuit filed against one of our communities by someone demanding tens of thousands of dollars back because we didn't open amenities. And that community's insurance carrier, as they should, immediately stepped up and said, of course, we're defending the board's decision to not open, the business decision to not open. So that's interesting. We'll see how that plays out. We think we'll be successful on that. The law, SB, if you want to look on the Georgia legislative site, SB 359, Senate Bill 359, it's been approved by the legislature. If Governor Kemp does not veto it or sign it before August 7th, it'll become law August 7th. That means it probably, if he doesn't, we don't know why he hasn't signed it yet, but if he doesn't sign it, it becomes law August 7th, operating beforehand. If something arises, claim happens beforehand, that law probably doesn't protect us. So it's only
prospective. It's
so
not
still a risk.
Agreed.
Okay, that's a lot of information. Again, in the handout section of your menu bar is the magic 2-sentence sign that needs to be put up if you are open.
And it's important, it needs to be put up at the entrance at each of your amenities. So I would put it up if you have a swimming pool that's open, tennis courts that's open, I would make a sign for each one of these sections.
Yeah, so take that. Also didn't mention earlier, but in the menu bar, you guys have been here before, there's a question section. We may not answer them in this session, but we'll get back to you on questions. And we love your questions or comments. So we'll take those and we'll get back to you individually. Okay, next issue. And I'll tell you in advance, this is probably a trick question because it's not the right question. Can we legally require people on our common areas, common elements to wear masks? And I'll already give you the answer about why that's the wrong question. I believe yes, and I'll explain why, but the right question is not can we, but should we? Are we creating potential liabilities if we don't? And many communities have already created mask requirements, mask wearing requirements. So people ask, can we do that? We're getting asked that frequently. And generally, the question comes because we see so much of the media about people, well, not wanting to wear them, but arguing right or wrong. that states and cities and municipalities have no legal right. You're infringing on my constitutional right to not wear masks. And whether that's right or wrong, in reality, that whole discussion really doesn't apply to us. Most states, Georgia included, recognize that we as private entities are different than the governments. There isn't this concept of state action when we're enforcing our private rules. We can make private rules that do things like infringe on free speech rights, for example. And we're not subject to the state and federal constitutions that prohibit regulations that interfere with those. We have our private rights under our covenants. We've made contracts individually to allow us to have these extra powers. And almost every set of community covenants have provisions, covenants and bylaws, that let us, we know this, create reasonable rules and regulations on our common areas, common elements. And most of our covenants even specifically say those rules can be, they can cover things that are in the nature of us controlling, regulating, or operating our common areas. They are within our board's business operating authority to regulate and control. And our rules and regulations just have to be reasonable. And at least right now, going back to what is reasonable, who should determine the standard, the CDC and Dr. Fauci specifically in the, I forgot the name of his institute, National Institute of Allergy and Infectious Diseases.
Yeah.
The most knowledgeable on this subject have said not only you should wear masks, but not wearing masks is in fact causing the spike in the pandemic. So we believe clearly you could defend as reasonable, establishing regulations requiring masks. Now, couple issues, couple limitations on that. First is and we know we deal with this with the service dogs, emotional support animals, and others. We are required under the Fair Housing Act to allow reasonable accommodations when somebody has a disability covered under the act and needs some accommodation. If someone has a legitimate situation and asks for accommodation where they can't breathe based on some medical or healthcare provider advice, we probably have to allow accommodation. But generally, a requirement of wearing masks on common elements, we think we can defend. Now, the question again, should we do it? And I lean towards saying, yes, frankly, I think we should. Jamie started this in the amenity discussion that our obligation is to operate our common areas in a reasonably safe manner. What is reasonably safe? Right now, the healthcare professionals are saying it is masked travel. So if we are not doing that and something happens, we may be able to defend it that we made a business decision, we didn't think it was necessary, but a plaintiff attorney is going to say, look, who's the smartest person in the room? You or the healthcare professionals and scientists who say do this? So I believe there is a risk in us not doing this. Now, we can craft how those policies look and what those regulations look like, but I think the answer is yes, we can, and frankly, yes, we should.
Yeah.
Jamie, you agree?
Yeah, I totally agree. Masks, as we've heard on so many different news channels, so many different sources of information, masks are what is going to help us stop the spread. And it's one of the things I think we can easily do, especially on our common property. Our common property is private property. And almost every single set of documents that we have gives us the ability to do reasonable rules and regulations on our common property. We're not telling them wear a mask in your house. We're telling them when you're using our property that we own or we operate, you can't do so unless you're wearing masks. End of story.
Property that by its name is defined, considered to be commonly used. It is intended for lots of people to use together.
And
so,
to do that, you should be masked.
Yeah. I agree. So that's our thought on the mask issue. We we love hearing from you. Thank you so much, Jamie. Thanks for doing this. We are putting out a blog in a little bit. Again, visit our website at ljlaw.com, resources. And one of the other laws that came through, you may have seen information about, is a law that is potentially restricting some of what we can do in the future with amendments regulating leasing in property owner associations, subdivisions, not the condos. There's been a lot out there about how it is going to destroy community associations. I think that's overblown. It's really much more limited than that. But legislature's been active on things that affect us, the immunity bill, that. In reality, again, we think it's stay the course. If you're going to open and operate, do it exactly the way we talked about 3 weeks ago and 5 weeks ago, following DPH guidelines and being very careful about it.
Absolutely.
Okay, we're going to keep this open for a few minutes if you want to continue to ask questions or send comments in the question bar. We
Just
want you to visit our website, and we miss you guys a lot. We hope there's a time soon when we can see you again. Stay safe, everybody. Have a great 4th of July. Thanks for joining us.
Yep. Remember July 21 for our 3-hour CE class on board meetings, annual meetings, and special meetings on electronic platforms.
Thank you, guys.
Bye, guys. Have a great holiday weekend.
I'm just a bill. Yes, I'm only a bill. And I'm sitting here on Capitol Hill. But I know I'll be a law someday. Oh, I hope and pray that I will. But today I am still just a bill. If the governor signs me, then I'll be a law. And I hope and pray that I will. But today I am still just a bill.